All right, ladies and gentlemen, my name is Robin Ramsay. I'm actually probably just gentleman from what I can tell, but my name is Robin Ramsay. I'm a judge or magistrate for Denton County. So part of my job on most days is just to meet with people to tell them of what they've been charged, their rights, and their bond. Bond, of course, is the amount of money that you would need to post with the court of the county before they let you out of jail. And once you pay it, you can go, but you do have to come back for court at a later date and time. If you don't come back for court, well, they'll issue another warrant for your arrest and kind of starts all over again. So make sure you make your court appearances. These are our magistrate arraignments for Friday, the 29th of October, 2021. It's now about almost 11 o'clock. I tell you that because this is a court proceeding, which is a recorded proceeding. So we do that for two reasons. First of all, it is a record of the court, but probably more importantly for your purposes this morning, since it is recorded, you still might want to be careful what you say because it could still be used against you at a later time. You can post the bonds in full in cash if you have that kind of money. Most people do not, so they go through a bondsman. Bondsmen charge percentages, normally between 10 and 25% of the total amount that I tell you, but kind of depends on whatever you can work out of the bondsman. Different bondsmen do charge different rates. So what I would suggest you do, call a friend or family member, tell them in the Denton County Jail how much your bond will be and let them work on trying to get you out. Now, if you can afford to put the money up in full in cash in the long run, actually save a little bit of money because then when you come back to court, you will get to pile that money toward the fine if you're found guilty. Or if you're found not guilty, the case dismissed, you're going to get all that cash back. But again, that's only when you post the money in full in cash. But if you cannot afford to do that though, you can go through bondsmen. Again, bondsmen charge about 10 to 25%, depending on factors that they might consider as risk. Other than that, so each of you here absolutely have constitutional rights. You always have the right to remain silent. You do not have to talk to the police at all because anything you say can and probably will be used against you later on. So again, you still want to be careful what you say. And while it's kind of unusual to see the police agencies want to come down here and talk to you after an arrest, they could. And if they do come down here, you can talk to them if you want to, although I just advise you of your right to remain silent. But if you give up that right and start to make a statement, you can always stop or terminate that interview at any time. Just because you begin doesn't mean you have to continue. You have the right to speak with an attorney. Have an attorney present during questioning and have the attorney represent you at trial. And if you cannot afford to hire your own attorney, Denton County will appoint and pay for an attorney for you. Or if you're on a warrant from a different county than that county, will appoint and pay for an attorney for you so long as you're truly indigent. Indigent means that you don't have a job, source of income, family, friends. You don't have any way by which you think that you can arrange to hire your own attorney because you don't have a job, source of income, or access to funds. And again, if you're here on a warrant from a different county, then we're going to notify that county that you're claiming to be indigent as well. But we typically have you fill out a sworn affidavit. It is a sworn statement, so it does need to be truthful and complete. And once the county has reviewed that information, and if the county finds that you're indigent, then we will appoint or assign you a court-appointed attorney. Although the court-appointed attorney has 2 to 3 working days after date of appointment to contact you. So you probably wouldn't be talking to an attorney until Monday or Tuesday of next week if you are given a court-appointed counsel. If it is a warrant from a different county, we'll notify that county electronically of your claim to be indigent. They'll begin to get their process started. And normally, though, you don't hear from that court-appointed attorney until you've been transferred into their custody, or if you do get out on bond and you're released, then you can contact that attorney before you go to court in that county as well. If you're here on a felony grade offense, you're unable to post your bond after a reasonable period of time, you can also ask the court to release you without posting bond in an examining trial. Kind of a legal process that more often applies only to felonies, only when you have been able to post your bond and only when there's not been an indictment returned against you first. Last, but certainly most importantly, you absolutely still have the right to a trial by judge or jury. Just because you're charged and arrested doesn't mean you're guilty. You do have a right to a trial, but you would need to post your bond in order to get out of jail prior to going to trial. So again, when I call your name, come on up front. I'm going to show you this wide arraignment sheet. It has your name, charges, and bond amount. I'm going to ask that you sign it. By signing it, you're not saying you agree with it. You're just telling me you understand all that information. So let me start off with Ricky Morris. Mr. Morris, come on up. See, Mr. Morris, I have you here on charge of harassment. You can see where I marked out on that because I realized that you turned yourself in. And so I've reduced that bond. And I also normally place restrictions or conditions that would require you checking with Denton County Pretrial Services. But because you turned yourself in, the bond's been reduced to $2,500. So typically bonds been running about $250, $300 to get you out, but it is bondable. Do you think you can arrange for that bond?
Sure.
All right, then let me get your signature on that line, just saying you understand rights, charge, and bond. And then your initials in that top box saying you're not claiming to be indigent. And then you can go try to get your bond posted and hire an attorney, see what they can do to try to take care of this case, perhaps even before you go. And again, I normally require conditions of bond, but because you've turned yourself in, I'm not going to make any formal conditions. I would suggest it might be best not to ever contact that person again, right?
Hello.
Huh?
Yes, sir.
Okay, all right. Have a seat, we'll get this on the system. Hopefully you can bond out here pretty quickly.
Thank you.
Justin Runnels. Mr. Reynolds, let's see, they have you here on 1, 2, 3, 4 charges. These are not new cases. So they're old cases where your bondsman has taken the opportunity to go off your bond. So there's 17, 16, 17, 19. So that normally means that your bond, did you not stay in touch with your bondsman?
No, sir. I was actually in the hospital for about a month and a half.
Okay, you've got to keep your bondsman aware of what's going on, because if you don't, then they're going to issue warrants. So they're going to go off your bond. So it's possible they could still reinstate the bond, but they'd have to file a motion with the court. And there's one that's a felony case. So you have one charge out of Denton County District Court, 362nd District Court, warrant F20 2723 for possession control substance PG1. That one currently shows no bond. Now, it doesn't mean you can't get bond set. But once you have an attorney, the attorney can contact the court, maybe explain that you were in hospital and see if they can get a new bond set for you. Then you have charge of possession control substance group 1, 1 to 4 grams, MC 21065444, which looks like it's still an unfiled case at $15,017.19. Theft of property 107.50, MC 208828 at $2,017.19, and criminal trespass MC 208829 at $2,017.19. So those three are bondable. The one that is out of this filed on 362nd is no bond currently, but again, it is possible to get a bond set, but you're going to have your attorney contact the court, see if they can get a bond set. I've noticed that we've already assigned you or given you a court appointing counsel by the name of Namandi Eke. So we'll notify Mr. Eke that you're here. He can come talk to you and maybe get some that bond set for you, okay? So without saying you agree with it or admit that it's true, let me get your signature on that line, just saying you understand rights, charge, and bond, or lack thereof in one case. And then initials in that bottom box right above your signature saying you're claimed to be indigent and still in need of court-appointed counsel. All right, thanks. Have a seat. Dennis Snyder. Mr. Snyder, one charge of unauthorized use of a vehicle, warrant F21 2772 462. There is no bail currently on that. Again, it's not that you can't get bond set, but because they're saying you failed to appear for court, only the judge of the 462nd District Court, Judge Leanne Breeding, can set a bond for you. So if you have an attorney that can contact Judge Breeding and see if they can get a new bond set for you. But without saying you agree with it or admit that it's true, let me get your signature there saying you do understand your rights, your charge, and your bond amount, or lack thereof of a bond. Can you give me your signature? And do you have an attorney already, Mr. Snyder?
Sure.
I'm sorry, you do or you don't?
I don't have one.
You don't. Do you have a job, source of income? Do you think you can afford to hire your own attorney?
Period.
Okay, then let's get your initials in the bottom box saying you're claiming to be indigent and asking for a court-appointed attorney. All right, we will start the process, see if we can get you a court-appointed attorney, okay?
Thank you.
Thank you. Humberto Garcia. Mr. Garcia, one charge of contempt of court. It looks like it's a civil contempt. So I don't know that it's not really a criminal charge in true sense. It looks like it's a family law case for unpaid child support is what it looks like. So oddly though, it does have a bond on a civil contempt, but it's at $28,000 cash only. So if you have $28,000 in cash sitting around somewhere, you can post that as a cash bond. Typically, they go turn around and apply that toward the child support that might be due. But without saying that you agree or understand, this really isn't a criminal case, so we really don't technically arraign you. But let me go ahead. You still have the constitutional rights because it can be a version called failure to, or there is a charge for unpaid child support. We don't file it here in Denton County though. So let me get your signature on that line, just saying you understand rights, charge, and bond. It's not saying you agree with it. And do you think that you can, do you have an attorney on this case, Mr. Garcia?
Trying to get the bond.
Okay, do you have an attorney representing you in this contempt matter though?
No, I don't.
You actually are entitled to court-appointed counsel even on a civil contempt. So let me get your initials in that. Can you hire an attorney? Do you think you could? Do you have a job or source of income currently? Do you drive a truck for a living?
I'm a truck driver.
Okay. Do you think there's any way you can raise the money to hire an attorney, see if they can get get some kind of release order?
What that means?
Can you afford to hire a lawyer?
No.
Let me get your initials in the bottom box. And Angela, this is a little different. We probably need to notify the judge of the 362nd. He's claiming to be indigent. I don't know. We might call Larry Harbor and see what they do on this. It's a civil contempt, but he is entitled to counsel. So, all right, then have a seat. We'll see if we can get your attorney, try to get this disposed of some other way. Megan Frazier. Oh, Ms. Frazier, I couldn't see you over on that side. So you have 2 probation revocations out of Collin County. So these aren't really Denton County cases, although you have some Denton County cases, it looks like. But these are out of Collin County. Charge of possession of controlled substance, pen group 1, 1 to 4 grams. Probation revocation 199-83345 2017 and 199-82902 2017 for theft of property under 2,500 but 2 or more previous convictions. Also probation revocation, also with a bond of $5,000. So a total of $5,000 on each, so $10,000 total on these 2. But that would be in addition to your 1, 2, 3, 4 other cases. There's one out of Denton County for 10,000, Collin County for 10,000. Another one. So you have $20,005 to Collin County and $150,000 to Denton County. Let me get your signature on that form, just saying you understand rights, charge, and bond. That's a total of $170,005 in total bond. And do you have an attorney out of Collin County on these cases?
Yes, I do.
Is it one you've hired or court appointed?
Court appointed.
Then let me get your signature, your initials in that bottom box saying you still need us to notify Collin County and ask for court appointed counsel. All right, thanks. Have a seat. Preston Kitchens. Mr. Kitchens, one charge of assault causing bodily injury, bonds at $5,000 on that. Kind of a strange story. Do you live at the same address?
Yes, sir.
So bonds at $5,000. So bonds would typically run you about $450, $500 to get you out, depending on the bondsman, whatever you can work out with them. It is a Class A misdemeanor, so it is a misdemeanor, but it's the highest level. And again, it's an assault family violence charge. Family violence is described as anyone within the same household. So even though the victim was a friend of the girlfriend of Well, I was confused. There's no actual family relationship to this person, but you do live in the same household, so that's why it's assault family violence. So let me get your signature on that line saying you understand your rights, your charge, and your bond. You're not admitting guilt or agreeing to the charge. And then do you think that you can arrange for that bond once you get a hold of family or friends?
Yes, sir.
Okay, initials in the top box saying you're working or have some source of income to where you're going to be able to afford to get out on bond. And then you can go hire an attorney and maybe take care of this case some other way. And then there is, in this particular case, it's been a request for protective order. The protective order simply says you can't go within 500 feet of the property where you were living. So your stuff is your stuff, but you can't go there to pick it up. This order only exists for 61 days. It expires at the end of 61 days. So just make sure that you don't go back to that address and don't go within 500 feet of the alleged victim named Deanna Lowe, Lowe, at the address of 1209 Catbird Drive in Little Elm, Texas. Again, this order extends for 61 days. If you go within 500 feet of Deanna Lowe at her home, place of work, or school, or if you go within 500 feet of 1209 Catbird Drive, even if they ask you to come over, if you're there or within 500 feet, that's a violation of this order. You can be rearrested on a whole new charge. And typically those are very high bonds, if bondable at all. So without saying you agree with it or that you admit or agree that the charge is truthful, just that you understand that there is a court order that prohibits you from going to the house. Let me get your signature there saying you understand that. We'll give you a copy of this order before you leave. So just make sure that you abide by this order. Again, it expires in 61 days. Okay? All right, thanks. I would suggest don't follow the advice on your shirt in this particular case. It says I do what I want to do. And if you want to go home, you can't, right? Okay. All right, we'll get this information on the system. It takes about 15 minutes before the bondsmen start to see it, but you can call the bondsman and they can try to work on getting your bonds posted, okay? All right, thank you.
I got a question, sir.
Yes, what's your question?
If I try to get my bond, my family bond, would that release me? The 28,000?
Yeah, but it's 28,000 in cash.
Okay.
So the answer is yes. If you have $28,000 in cash, you can post it with the county. They typically will hold that and apply it toward any child support you owe. But we're not talking through a bondsman. You have to have it in cash. You must be doing better than I am because I couldn't come up with 28 grand in cash. Right? All right, thanks.
Judge.
All right. Well, thanks, ladies and gentlemen, and Martin.
Yes, yes.
All right.
Happy Halloween.
Yeah, I should have worn the big pumpkin costume.
Judge, I have a quick question.
Yes.
Call Larry and find out if we can get this guy an attorney or not.
Well, tell him that we have a civil contempt and he's asking for a court-appointed counsel. And it's out of I think it was out of the 362nd District Court. But ask them what our processes are when they're here on civil contempt. It looks like it's it looks like it's child support that's unpaid. But he wants a court-appointed counsel.
Give him a call as soon as I finish this.
All right, thanks. Bye.
Thank you. Bye-bye.